Yes, please speak. Mike.
Item number 1 and 2 are similar, Your Lordship.
What is the matter?
It's
It is appearing under to be mentioned.
This is my lord. Initially, the members of the union have a filed a writ petition, and in terms of the writ petition, they have been granted to 1/30th pay.
What?
1/30th pay plus DNS and also, no? They have been paid, and subsequently, this writ petition was again filed by the under the name of the union, saying that they are the members of the union. They have also entitled to get the 1/30th pay. But this court has directed us to verify the records whether they are the part of the union at initial stage or not.
Where is the petitioner?
Not as it has been required an affidavit, I just pray not because it has to verify from the records whether they have been union members or not. Because in the initial stage, this court has said that those are members of the union, they are entitled for.
Where is the council? You are appearing for council.
Municipal council.
So there was a direction to file some report.
Yes, my lord, because
Where is the report?
my lord, it is not been listed. My lord, it is after that, it is the second extension. My lord, I am just praying, my lord.
You have to inquire and file a report that whether they are entitled to the benefit of 1/3.
My lord, I will file it, my lord. Let me fix on Monday or Tuesday, my lord, subject to lordship kind convenience.
In opposition is also directed to be filed.
My lord, it is required an extension. Let me fix on Tuesday, my lord. I will file in the meantime, my lord. Let it fix on Tuesday.
Two direction was given. Number one, first inquire
Whether they are the member of that union or
member
not.
of the union or whether they are entitled to the
At or
benefit.
equivalent to that benefit which is been
Number one.
accrued.
Number two, if you admit that they are entitled, then
The number two
matter
issues
will be
are
disposed of.
yes, ma'am.
If you dispute it, then you can file your opposition.
Yes, ma'am.
Both order was given by the coordinate bench.
Yes, ma'am.
So you want
Let me fix on Tuesday or next Tuesday, ma'am.
if it is admitted, then I will dispose of. Otherwise, I will post.
Yes, yes.
Same orders.
Item
Second
two,
one is also
same-
same order. Same order.
same order.
Same order.
Your 15 of 126. Petitioner. I guess they know item 3 and 40 that because the matter is same, you know, starting with that.
So that was released. Released. Okay.
Mention of the item number 3 and 40. Sorry, the 3 and 11.
I am coming 11 later.
So, center of 126.
I have been instructed by the respondent to appear. Actually, I used to appear for the state. State is the party. Yesterday it was appeared, but petitioner did not move. Now he is on BC.
He is in
BC.
person. You are appearing in person.
Yes, sir, I am appearing in person, sir.
Your mic, switch on your mic. You are not audible, sir.
Yes, hello, is it audible now,
You are
sir?
not audible. Some problem.
Okay, sir, can you adjourn the matter? Can you fix the matter on the next circuit, sir?
There is some disturbance in your voice.
Sir, can you fix the matter in the next circuit, sir? Next circuit, sir. My laptop having some problem, I guess, sir. Some problem is in the laptop.
Unable to hear.
Sir,
You are
please.
not audible.
Hello, sir. Is it audible now, sir? Is it audible?
I am keeping not today.
Sir, kindly fix it in the next circuit. Next circuit, sir. Next circuit, sir.
It is
Next
very
circuit.
difficult. I
Sir,
am
can you
keeping not today.
next circuit, sir? Next circuit. Next circuit.
Next.
Next circuit.
No next circuit. Why next circuit?
Sir, my laptop is having some issue, I think, sir. Not audible, sir. I don't know.
Okay. On the prayer of learned counsel, on the prayer of petitioner in person, this matter we listed before the next event, subject to its convenience.
Copy not received.
Thank
In the meantime, petitioner is directed to serve the copy of petition upon the respondent and file affidavit of service on the adjourned.
you.
My appearance may be not that.
Out of the present and on the question.
Obliged.
Thank you.
My senior appears for the petitioner's bill. Yeah, my lord, yesterday a similar matter was withdrawn by us in court number 1. Here is the order. Both are connected matters.
So you want to withdraw
Yes, with the liberty to file before the appropriate court.
on the prayer of the learned counsel, on the prayer.
My lord, I'm preparing for the explanation.
In this matter, item number 5.
No, 6.
6. Yes, you have challenged the order of the trial court, which was passed under section 26 rule 9.
Yes, ma'am. My senior appears.
Yes. Proceed.
Hello, I am appearing.
Yeah, fine.
My lord, let it be just not today.
Yesterday also,
Just not today, my lord.
not today.
No.
Okay. On the prayer of learned counsel appearing on behalf of.
Okay.
The last chance for the day.
Each time I might supplementary action.
You are the respondent.
Private respondent.
I'm an official respondent. She appears. Counsel, petitioner appears for virtual voice.
Who is he? Virtual mode. Nobody is there. What order has been passed?
February 6, 2026.
Uh,
Right respondents of the
No, impugned order dated 30th/9/2024 passed in SR by whom? By the Tehsildar. Is the second appeal or first appeal?
Yes, and the second appeal.
Second appeal. Passed by the commissioner. Revenue Secretary Revenue is the second appellate authority.
After SDU. For the plaintiff. She's paying 52 million.
1 minute, I am going to the order. Yes, what do you want?
I seek time to file my supplementary affidavit
What supplementary affidavit you will file?
regarding
They have already filed their opposition.
position you have filed.
Well,
What supplementary affidavit you
In
want
the
to file?
opposition, they
There
have
are
fixed everything.
several civil suits are pending
Hello.
on the same subject matter.
My lord,
Only on
Petitioner-
that ground,
Petitioner has
it
filed
was,
this-
huh?
petitioner has filed this writ application, my lord.
That's why I'm asking.
Yes, my lord, and he is one of the
Why
plaintiffs.
he will
Before
file
the trial.
supplementary affidavits?
He has annexed everything in the opposition, my lord, copy of the plaint, our written statement.
It is disputed that there is no civil suit is pending against the petitioner between you and petitioner
Pending.
pending. So how read will lie?
Yes, he is not understanding. Even I have informed that you leave senior, writ is not maintainable at all.
Not maintainable at all.
And their opposition is on record, my lord. Their opposition is on record. Well, let's see. They have already filed their
When
opposition.
the similar subject matter which is subject matter of this writ petition is pending before the civil court. Civil court will decide.
Fine.
And this is regarding to the right of the land. Right and title of the land.
Encroachment land, my lord. It is their case that they have encroached a government revenue land. And the petitioner is saying, no, it's allotted land in their favor. That is a dispute.
And what was the order of the SDO?
My order of the STU. My lord, starts from page 43, my lord, P6,
43.
43.
Yes, 43.
My lord, 44 is the dismissal order. This is the starting, 43.
Yes, see.
Is there, my lord?
My lord, I am appearing for the private respondents, my lord.
Appeal was dismissed. It's page 44.
My lord, in terms of regulation 160, the civil suit is pending.
So
So he's there. my lord. Sorry.
I am for the private.
when there is a civil suit is pending,
My
so
lord.
how this?
It is there.
That is the reason in our affidavit and opposition, they have taken a specific stand.
Where is the petitioner?
In the
Petitioner is
opposition,
not
they
appealing.
Petitioner
have
advocate
the
is not
copy of
there.
the plaintiff.
It's not okay.
Until and unless the civil suit is decided, my lord, we are also
And SDO also dismissed this,
dismissed.
this,
First appeal, my lord,
first
then after
appeal,
the second appeal.
when no document has been produced
My
from
lord.
the side of petitioner.
My
Okay, today, tomorrow,
my lord.
not today.
I'm for the respondent.
And he's out of station. I have prepared my updating reply and I will serve a copy to my learning for advance copy.
When do you want?
Monday.
Monday.
Monday. My client is coming on Monday. I have requested.
Lordship, asking you here for the respondent, Lordship.
Respondent,
Yes, sir.
please speak a little louder
Yes, Lord.
so
Sorry,
that
Lord.
I can hear.
Yes, Lord. Lordship, yeah, yesterday was direction was to file the affidavit of opposition, Lordship. We have filed and we have give you a copy to us.
Position ready?
Yes.
Lordship, I will be filing my reply to it, Lordship. Praying for 2 weeks time.
Why 2 weeks? You are not interested in your case.
Oh, okay. I have just received the copy just now.
This case is regarding compensation.
No, Lord.
No, Lord.
The petitioner were.
Oh, yes,
No,
yes,
no, yes.
waiver of the interest.
No, no,
No,
no.
Lord.
The petitioner were.
They were appointed during the COVID.
COVID.
Yes, COVID warrior.
They were appointed at the time of.
First wave of
Pandemic.
COVID.
A notification was there in the paper that they will be given for first preference. By time and again, the administration.
First preference of what?
First preference for
For
seeking employment,
employment.
Yes, at the post of Aya and like that. But time and again, they made several representations. This is a third round of litigation. So, I
So earlier round of litigation, what was the order?
in the first round of litigation, it was ordered that they should be given, they should be giving,
Preference,
preference, yes.
preference to.
But the administration was very clever. They have not given preference to me nor the other candidates. They have given and they have taken post from other posts. As such, I have filed my the
Second writ
application
petition.
also, but
Second writ petition, what was the order?
second was the contempt, lordship, contempt.
Contempt, okay.
Contempt. But Honorable Justice was even then, since it is a fresh cause of action, you file a new.
Fresh.
Yes. And
So you have
the
filed a
case-
fresh.
Yes, yes, first, this is first.
Is there any vacancies available or any notification?
Still there is vacancy pending at the relevant department of Aya and everything, and they are.
What is the procedure of appointment of Aya? Is there any interview process or
No, Lordship,
direct recruitment?
no, sir, there is a interview only interview.
Only
and-
interview.
And because of that only. my
Whether any notification is given by the government for appointment?
Lordship, I would just.
Lordship, during April 2023, there was a vacancy notification given, Lordship.
Vacancy declared.
Yes.
But whether any notification was.
Yes, sir, and Lordship, they were permitted as per the essential, the qualification and they can participate in the process, selection process, Lordship. They have not.
Position.
Yes, sir, yeah, Lordship. In this Lordship, we have filed all the.
Fine,
I will reply, Lordship. I will come.
within three days.
Lordship, I need some time.
Right.
Let it be a week, Lordship. Let it be a week.
In April, notification has been published, you participate there.
Lordship, I pray.
We have not barred them from participating in the latest notification, vacancy notification, April 2023. We had advertised, yes, Lordship.
Yes, selection process completed,
No, Lordship.
still going on.
Yes, Lordship.
When is the date for interview?
Lordship, we just, let me clarify, I'll get back.
You have not mentioned it.
No,
was-
Lordship, because this, we only given they were only challenged, before, during the COVID period, Lordship, we have had a temporary contractual appointment I made them. And during the second wave, Lordship, since there was a notification from the Government of India regarding isolation, self-isolation, so the number of required personnels were limited, Lordship.
There were 3 COVID waves, Lordship. In all the 3 waves, I had given my service. And after giving my service, it was categorically mentioned that preference will be given to the candidates who have done their service. in
No,
COVID.
first of all, you have to appear before the interview board. They will give preference to
I
you.
have already applied, but they have, I have applied, I have gone through the interview process, but they have not taken it. And they have taken who are near and dear to their higher officials. This is the case, Lordship.
Okay, you file within 1 week.
Yes, Lordship.
Also, in this matter, I am for the petitioner, I challenge the order passed by the learned Judge Family Court, wherein the learned Judge Family Court passed an order providing maintenance amount of 12,000 per month. From one, I'm just seeking and also filed a CAN application that is under Section 5 limitation. That has to be disposed of so that I can serve the other side of. The 33 days of delay is there.
Where is the improved order?
First thing, Section 5 application, you can get one. That has not been.
Section 5 is there.
Yes, sir. 33 days of delay is there.
Why you have not served the copy? Two occasion it was heard.
Section
No,
5 is
no order has
not
been
allowed.
passed.
Yes,
Huh?
sir. Section 5 has not been taken into account, you have to be served. If this served the copy.
There is a section 5 application.
Not today.
Not today.
Your export matter was released from the court number one, not today. I don't 11.
After,
11, not today.
not today.
Similar matter, this day I released from the court number one.
So tomorrow,
Tomorrow.
okay, on the prayer of
Here, here 25 or I have to from petitioner, they have to file the affidavit. Twice in
affidavit in reply,
affidavit in opposition.
opposition. Yes, sir.
Your lordship, there's no direction given.
There is no
Represent-
reflection.
No lordship.
This requires an affidavit of opposition. This cannot be disposed of without.
Without evidence, how you can say,
No, there is no representation to consider, madam. There is an order passed by the authority.
even then, court can hear it out. Whether it will be admitted or not, that will be the question. What is the matter about?
So here, this petitioner is the recorded tenant of a land. Bearing survey number 284/2. And on the basis of a sanction.
What is your prayer first?
To set aside certain orders, my lord, which were passed by the municipal authorities, whereby. My lord, may kindly come to page 23.
23 years. There are two orders, both 11/2019 and 11/11/2019.
Well,
These are two orders passed by the respondent number 4,
municipal authority,
municipal authority. Regarding demolition,
yes.
what is your grievance?
I say, my
Whether-
lord, yes, under the dint of a valid sanction plan, I constructed the building. The building plan is annexed.
Where is it?
Enclosed. My lord, may kindly see,
Please come to order first.
no, if my lord intend to see the building
Please
plan,
come to order first, thereafter I will go through the sanction plan. Where is the order? Earlier writ petition was filed,
Yes, lordship.
earlier writ petition was filed.
this is second round of
First
litigation.
round of litigation, what happened, my lord, they have not communicated an order and they intend to execute the order. So I made this.
So opportunity was
The
given,
court said, to place the record whether it was at any point of time served upon the petitioner or not. When they filed the entire record before this court, it was found that they candidly admitted that it was never communicated to the petitioner. And the court has given an interim order also, protection also, that in the event it was not communicated, if my lord may kindly.
what is the order earlier bench? What is
Page
the bench?
65, ma'am.
What is 49, page 49? Then what is WPA 5 of 2022?
This was earlier round of litigation.
What was the order?
There some construction was going on, somebody has filed an application, appeal were pending to dispose of within a time frame. Yes,
So you have challenged the order of demolition
yes,
before the appellate authority.
appellate authority.
What about the result?
Page 65, if my lords come, appellate authority mechanically upon the order of the municipal authority. That was not communicated. That's why I have taken a writ petition, page 65.
Okay. Second writ petition.
Yes. Now, if
Earlier writ petition was filed by the private respondent.
private respondent,
This was filed by you.
this is the first writ petition filed by.
What was the order?
My lord, may kindly come to. Kindly come to page.
Order suspended for a period of 30 days from the date of.
The earlier orders were quashed by the court, whereby they intend to execute the order. Because
So there was a specific direction that you have to file second appeal within 30 days. You did not file within 30 days.
second appeal, madam. If I agreed, I have to file.
Come to the page number 67.
Yes.
What was the order?
Accordingly, the said order is suspended.
For a
For
period of
from
30
the
days.
base of this order, it is very clear that in case the petitioner challenge the said order, and I have challenged before this court now.
Why?
Said.
No, 21st/5/2025.
Challenge the order dated so and so, the order, yes, that order.
Shall
is
stand quash and set aside?
Yes.
Thereafter, in case of petitioner does not challenge the order dated so and so passed in second appeal within 30 days from the date of this order, where you have to challenge that order.
Before this court, after second appeal was dismissed, this is the order passed in second appeal. Order dated 21st. That is the subject matter of the writ petition, page 24. The Blair.
And you have not filed within 30 days.
Within 30 days, I have filed this writ petition, my lord missing.
So why they have passed second order? You come to the paragraph 10. Read first.
Yes. In case the petitioner does not challenge the order dated 21st May 2025.
Passed in second
Second
appeal.
appeal. So second appeal, an order was passed, 21st of May 2025. Within 30 days from the date of this order, the order of suspension in respect of order shall stand automatically vacated. Now, my lord, within 30 days, I have filed this writ petition challenging the appeal order of the second appellate authority.
So now what order has been passed, second order by the competent authority? Eleven 2019.
No, last order by the second appellate authority is at page 56. Page 56.
This was the subject matter of this writ petition.
Yes. So this I have to have challenged within 30 days, and I have challenged it within 30 days. So the subsequent orders were set aside by the court, and that remains. So now in this matter, my lord, they have to file an affidavit to demonstrate how this order will sustain.
Yes.
So, Lordship, the direction be given, we will be filing affidavit over it.
No, sir, no. That order was passed by the earlier bench. That second appeal was dismissed without giving opportunity, without serving.
Without serving.
Without serving.
Yeah,
Serving means without serving.
No, the order in film was not served, my lord. 21st May.
That's why that order was set aside. And further opportunity was given to file a fresh appeal
No.
before the second
No.
second appellate court.
No. Because the appellate authority, though conducted a hearing, but the final order was never communicated to me. So when the final order was not communicated to me, they intend to execute the order. I approached this court and I said that at no point of time final order was communicated to me. Therefore, there is no question of execution. Court called for the record. They candidly admitted before the court that it was not served. On the basis of that, all the execution proceeding was quashed by the court.
Set aside.
Now,
And liberty is given to file.
and on that day, they have served me this copy and liberty was granted to challenge it within 30 days. That I have done, man.
Okay.
They were a party to that municipal authority.
What was the deviation? What was
They
the,
say that the construction was on and above, there was certain deviation, measurement and all, they are saying. So that let them.
that is
file-
permissible in regulation that they can be.
Regulation it is compoundable, regulation it is compoundable. They, my lord, they are not at all considering the division bench judgment, this is binding upon them.
Oh,
Your Lordship, my senior appears for the respondent, Your Lordship. Your Lordship, 2 weeks time were given, Your Lordship, for filing a appeal, but 2 weeks are not yet over, Lordship. But I think by mistakenly they listed the matter, Your Lordship.
so you want to 2 weeks further time?
Lordship, 2 weeks were granted. It's not yet. After the 2 weeks, I will be filing within a 2 weeks, Your
So
Lordship.
you want extension of
1 week, 1 week.
1 week. The prayer.
Lord, in this matter, I appear for the petition, my lord. Lord, the affidavit of service has not been effected. Let it be fixed on day after tomorrow.
What is prayer your,
My lord, for granting electricity connection.
whether that was rejected?
My lord, that was not rejected. It is still
Order
pe-
consideration.
yes, it is still pending.
So I am sending the authority. This was a,
Lordship,
But the-
generally I used to appear
Yeah,
on
parts have the
behalf of
copy to the other side.
I am disposing why necessary. It is not necessary.
Well, let it be disposed of.
Lordship, at least I could have get a copy and I should have, whether they are having any house or not, I have to go through it. वो तो डिस्पोज ही करता है
But they have complied, not, because they have to give an opportunity of hearing and order has to be passed. It has been done, we not, let them give a copy.
You are for the,
For the petitioner, the authority of hearing has been given to the petitioner. But,
what was the order?
like the order passed by this.
I don't have the copy of the contempt petition.
If one, the secretary was directed to comply with the order. That is not yours.
What was the order? The order was passed on when? April 3rd, 2024. WPA 100 of 2022.
Yes, no. Let it be fixed, not fixed.
Whether hearing was completed?
Yes, hearing was given. In 16th of January, the hearing was given by the respondent of it. After the order has been passed by the respondent, it has been not done. Let it be posted to the member of it.
Order has been not passed.
Pass.
Order served.
Not served. Let it be posted tomorrow, not served.
Order has been served.
But I just let him give a copy of the contempt petition. I file complaints, day after tomorrow, so that I will.
No, this order was passed in the year 2024.
It has been done, it is, hearing has been done, I will not today, then I will.
So you file compliance report. Where is that?
Because we don't have the copy of the contempt petition, it has not been served.
So tomorrow you can file.
Day after tomorrow, let the copy of be served to us. So that we can know who is the contemptor, and based on that, we have to file a complaint.
The last occasion, the learned counsel for the alleged contender seek an accommodation for coming up the better instruction from his client.
Let's be a complaint.
So how you can appear? You have already appeared here.
No, I appeared, I said the copy has not been served.
They have to tomorrow.
They said they have to just serve the copy.
Just serve the copy.
Then kindly see the first order.
Yes, serve the copy. Right, now it's.
Learned counsel. Learned counsel is further directed to take if you have complied, you have supplied, then I will dispose of this contempt application, let them file.
Well, it is in their favor only.
Oh,
It
their
shows
favor.
that, they want a shop in the panchayat premises.
That was allotted.
That was, it says that he will be given first preference in allotment of shop as and when the panchayat market rooms are there, because the construction going on, the panchayat rooms.
Oh, okay, they will one
He will be
panchayat report.
allotted as and when it will be.
So you file report, simply one page report
Yes,
is
yes,
sufficient. Next day.
My senior is counsel for the petitioner. I pray this case to be placed before Honorable Justice Jayaswati Gupta.
For the architecture. There are many CAN applications are there here,
What are those CAN applications?
for substitution, setting aside abatement and continuation of billing.
Have you solved the copy?
Your Lordship, the affidavit of service which was filed in the month of August 2025 itself, it reflects all the track reports, says all the proposed legal heirs. They have been
So why order has not been passed as yet?
even for the one of the respondent on the last petition, Advocate Vijay Kumar sir appeared. And he has asked for time for filing objection.
So direction was passed by the coordinate bench for filing affidavit in opposition and reply, whether it was filed.
No, Your Honor.
So,
With regard to my CAN application, no affidavit in opposition has been filed, no objection. And on the last petition for the respondent number one, that is one of the legal heirs, one counsel had appeared and he had asked for time. But today, I find no one is there for representing the first respondent. So far as the other respondents are concerned, the affidavit of service filed in the month of August reflects that.
you know whether you have solved the copy to the all legal heirs,
Yes, Your Lordship. My affidavit reflects the same.
but that direction was again passed.
I believe, Your Lordship, in the month of December, the council, junior council had appeared. Mistakenly, the council failed to inform the honorable court about the service.
No, last occasion it was directed to inform the learned counsel for the respondent. Have you informed?
Yes, Your Lordship.
Where is that?
That is why the respondent number one, counsel for the respondent number one had appeared on the last occasion.
No. On February 3rd, 2026, the learned counsel for the appellant is to inform the learned advocate on record of the respondent number one.
Yes, sir.
Have you informed? Where is that?
Your Lordship, on the last occasion when the council had appeared, then again
Have you gone through the order of February 3rd, 2026?
Your Lordship.
There was a specific direction that you inform the learned counsel for the respondent number one.
Your Lordship, I shall take necessary steps with regard to that.
You inform the
Yes,
learned
sir.
counsel.
Your Lordship.
As a non appears on behalf of the respondents. Only one respondent.
Respondent number one.
Only one respondent.
Only one respondent had appeared, for the other four respondents, nobody had.
Respondent. No accommodations or. The petitioner is directed to inform the learned counsel for the respondent with regard to the pendency of this case and next date of hearing. Just you inform.
Your Lordship.
If they will come, okay. If they will not come, I will pass the necessary order.
Your Lordship.
Release this matter on 19th. Can you inform 19th?
Your Lordship, on my 19th, I said. Because the council that.
Hey, Vijay Kumar, where practice here?
Yes, Your Lordship.
You inform.
Your Lordship.
On 19th, I will.
Your Lordship. Oblige, Your Lordship.
All parties shall act on the server copies of the.
In 18, I will see for one of the 82, that is 19,
But here appears for the petition and item number 8.
Mr. Tabris appears
18 and 19.
corrected. In item 19 में sir appears
17. This is item number 17.
18 year.
Oh, 18 and 19.
18. I'm paying for not today, but in item 19.
Not today.
Not today.
Why?
Machine appeal appears and argue the matter. Today has some further difficulty. I'm paying for not today.
Okay, not today.
आपको तो कंसर्न क्या उनकी Dear minutes to learned counsel Lady Shobha is appearing for the appellant and praying for not putting minutes of he is in court number 1 on leg minutes.
What is the matter?
It is appeal matter against the award by lots of the tribunal matter, motor accident claim tribunal.
देखिए रिकॉर्ड What was the award?
Yes, sir. It is at 2 lakhs,
2 lakhs.
my lord.
Injury case. Injury case.
My lord.
Why you have agreed?
My lord, in this case, it is under section 170 of MU Act. This
You have deposited statutory amount have been deposited.
My lord, it is deposited. It is deposited by order dated 4th April.
And lower court record has said. Lower court record. Yes, sir. No. Yes, what is your challenge? Have you served the copy to the insurance company?
My lord, it is a government vehicle, STS department bus,
Was
passenger bus. We have served to the respondent and they have appeared.
STS, sir.
Yes,
Have you served the
I
copy?
am appearing for the transport department.
Appearing for the appellant?
I am the appellant, the respondent earlier, somebody from,
The appellant.
yes, one Yasmin Begum appeared on the behalf of State Legal Service Authority.
Why you have challenged this? There was no any accident.
The accident was there, my lord, but
So- No injury suffered by her or him
the
or she suffered injury.
we have filed the affidavit of service, my lord. My ground is that there is no proof of rash and negligent driving by the driver. And there is no disability certificate has been produced.
Even if there is no disability certificate, he is entitled to compensation.
The learned tribunal's findings are internally
That's why
contradictory.
the amount was very less. Otherwise, the amount would be high. PW1 corroborated, PW2 victim, PW3 eyewitness, FIR, written
See-
complaint, charge sheet. What else required to prove rash and negligent driving?
The award cannot be based on emotion, my lord. It has to be
Emotion,
Just
what
down.
emotion you are talking about, sir? A lady had an accident.
my lord.
She suffered injury. And you are talking about emotion.
There is no eyewitness, no.
Who said there is no eyewitness? The PW3 is eyewitness. What witness brought from your side? No any witness deposed from your side to rebut their contention that an accident was not occurred. She did not suffer injury. The contents of the discharge report reveal that the surgical incision took place in the right femur shaft of the victim in process of treatment post-accident. You are saying there was no medical document. Medical document is also available.
Disability certificate is not there.
Victim was a student of class 9. Then she suffered ill-fated accident. What required?
No medical
No
bill.
personal income is also taken as a 15,000 per annum.
Yes, my lord. There no income certificate has been proved.
There should not be an income. Income is rightly
No medical bill has been submitted, my lord. No,
taken. 2 lakhs is
No.
sufficient.
no evidence of long-term
It may
bad
be
ailment.
extended. It may be extended. Okay, hearing concluded. What is the party?
But I am seeking extension of time to file report. Report बोला था.
What report would you want to file?
There is a direction upon the Tahsildar to submit.
Direction. Opposition filed.
Yes,
You are for?
I am filed. Opposition
Who
filed.
is appear- You are the petitioner.
Hearing was done during the last circuit. In course of hearing, the authorities were directed to place certain report. They are supposed to place it, now there are orders of the school. The report was directed to be placed before this court.
A week's time may be granted, my lord. We will file the report.
Sufficient time
Yes?
has been granted, madam.
1 week time may be granted, my lord. Extension of time to file report. There is a transfer in the. Yes. There is a retirement in the incumbent. New Tahsildar has joined.
You have challenged the second appeal order.
Order, yes. But this court, by its lordship, Honorable Justice Prabhakar Chakraborty, allowed my appeal, repetition, dispose of it. Certain direction was given to the authority to take decision. But the authorities time and again taken decision in derogation to the order passed by his lordship. Those orders were challenged
was set aside, it was remanded back. The order one which I have challenged lastly in the present writ application is in the same line. Same line. The entire matter rolled up with the order of Justice Tapobrata Chakrabarti.
What was the order?
The order was, the private respondent says that I have encroached his land. We both are adjacent doorholder. Tahsildar passed an eviction order so far as my client is concerned. I challenged that order. This court said, you take a decision afresh, but before taking a decision, what I have said, that there is a less area insofar as my property is concerned, that needs to be decided. That was not decided. Till now. Even the last order which I have challenged in the present writ petition do not decide it.
Why that will be decided?
Because our court has said, His Lordship Honorable Justice Tapobrata have said, take a decision in respect of the contention of both petitioner as well as the private respondent. The authority have taken decision based on the contention of private respondent. My contention was not taken care of. This type of order was passed previously also twice. It was set aside by the court.
What was the area of your land?
Well, I have records to show that the total land held by me.
As per record.
Land record is here. Yes. It's lesser area. So I'll show that also. Page 28 may kindly be seen of the repetition. And I'll show the order of His Lordship. Clear cut order dated 2nd February 2018.
No, you have obtained the sanction plan.
No, it's not a question of sanction. Yes, plan is there, but that is not the point. Plan is there.
You have
Yes.
plan
Yes.
of your own land.
Yes.
What was the total area?
I'll show the Lordship. It's in terms of the land record. Page 28 may kindly be seen, Lordship. Page 28. I have raised my building over my recorded land, but the Tahsildar says that building is over the land of the private respondent. That's the dispute, my lord. Page 28 may kindly be seen, my lordship.
Yes, 28.
My lord would find land record. Ghulam Mohammed. There are two survey numbers. My lord would find serial number 5, two survey numbers, total area 0.90487 hectare.
So you are entitled for 0947.
Yes.
And you have obtained
Sanction plan. Yes.
plan.
Yes.
You have constructed.
Yes. Now the authority says.
As per your
Yes.
sanction plan.
Yes.
There was no dispute. Only dispute arises when the respondent
Made a complaint.
objected that some portion of his land was encroached by you.
And my building cantilever falls within the enclosed portion. Cantilever is the disputed portion.
Only cantilever.
Cantilever. But my case was, my lord, before the writ court and all through, that the record shows something else.
After measurement, your area was reduced by.
Yes, absolutely. Absolutely, it was reduced. Tahsildar did not consider it. So when I approached this court, His Lordship Honorable Justice Tapobrata clearly said to take decision on both the points. What Mr. Jaipal's client is saying, take a decision, and what Mr. Khan's client is saying.
Where is that order?
My lord, it's an order dated, I'm just placing, already it has been placed. It's an order dated 2nd February 2018. My lord. It's my writ petition, Lordship. And my lord, I will show that portion of the finding arrived at by His Lordship. My lord, last but one page may kindly be seen, Lordship. Last but one page of the His Lordship's order. In reply, Mr. Jaipal it starts with at the top. In reply, Mr. Jaipal submits that the quantum of land in plot bearing survey number 35/3 and 34/3 do not tally with the land as specified in respect of plot bearing survey number 78, and it disputes the fact that the new survey numbers have been allotted to the plot occupied by the petitioners bearing survey number 35/3 and 34/3. Heard the learned advocates appearing for the respective
What
parties.
similar plot number will be allotted?
No, sir. There is a survey done. So that number was given a new survey number, but the area has been reduced. So my contention was, while giving a new number, you reduce unilaterally the area. So my submission was recorded.
So physical measurement, if your land is reduced, then why not they will reduce your area?
No,
This new survey.
but the old record, which do form part of the writ petition, depict the clear area.
I am giving an example.
My lord.
Somebody purchased a land,
My lord,
and after measurement, it found it reduced.
my lord,
What is the remedy?
my lord. But if the reduction is based on the authority's action, then that would be challenged before a writ court.
So
Had it-
have you made any allegation that my land was
Yes.
encroached by someone else?
No, it's not a question of encroachment. My point of argument was, my lordship, the building which I have raised is over my land. That's first point. Second, even there is a reduction of area.
So this court in the order which I placed just now said,
Please read
my
the,
lord. In reply, my lordship heard the learned advocate's third paragraph, appearing for the respective parties and consider the material on record. In paragraph 4 of the affidavit in opposition filed by the respondent number 4, it has been categorically stated that the plot bearing survey number 718-2 belongs to petitioner. A perusal of the report dated 6 November 2017 reveals that the demarcation was conducted in respect of plot of land bearing survey number 783, and it was
783 is the respondent.
Yes, my lordship.
Respondent.
Yes.
Second respondent.
Yes, my lordship. And 782 is mine, adjacent plot. It was found that an area of 9.88 square meter has been encroached upon. From the survey report, it appears that the petitioner was present and he recorded an objection pertaining to such demarcation. The contention issue, now that's vital, that the contention issue is as to whether petitioner's land bearing survey number 35/3 and 34/3 correspond to new survey number 791 and 782 respectively. Upon arriving at a finding as regards the issue, it can be finally determined as to whether the petitioner has encroached upon the portion of land bearing survey number 783. Such an issue involving disputed question of cannot be decided by the writ court, and as a proceeding, regulation 98/161 of the said regulation has already been initiated by the respondent number 4 before the respondent number 3, alleging that the petitioner is encroached upon her land. The entire dispute raised by the petitioners need to be relegated to the authority adjudicating the said dispute. Accordingly, the writ petition disposed of, directing the competent authority conducting the proceeding under regulation 98/161 of the said regulation to consider the issue agitated by the petitioner herein as discussed above and to take a final decision forthwith. So, writ court had clearly directed the authority take a decision on these two counts.
So what was the order?
Order of the Tahsildar, I'll show, which has been challenged here, which has been affirmed thereafter. I'll show you. The first order of the Tahsildar, it's at page 51. Page 51. Nowhere, my lord, it records the reduction of area.
So only direction to vacate the honor.
That is all. That is all. That is all.
Of the respondent.
Absolutely. And this order was affirmed.
This was order
Affirmed at page 52 by First Revenue Appellate Forum. Affirmation. It's an order of affirmation. And by the Second Appellate Forum at page 54. It's order of affirmation. So my point of contention is, Lordship, when this court, writ court, have directed the authority to do particular act in a particular manner, then the Tahsildar is left with no other option but to take the decision in all the points as directed by the writ court. But where is the adjudication made?
What discussion made?
Nothing.
No.
Nothing. As regards reduction, nothing more. Kindly see page 51 and 52. The authority would have, it's their own order, they cannot support it. It's in clear-cut derogation of the order passed by this court on 2nd February 2018. I have sworn to be an encroacher. I do admit, no problem. But at the same time, what I have raised, there has to be an adjudication at least against me. You say so, something against me, but he has to say so because there's a direction of the High Court, but there's no finding as such, my lord. Even the First Appellate Court, Second Revenue Appellate Court has affirmed it. So this court, during the hearing of the present writ petition, asks the authority to place the report on record, based on which the Tahsildar have come to a conclusion. Lord would find nothing. All it says that I have encroached 9.88. That's all. What I have said, what is my argument, what the writ court have said, there is no whisper by the Tahsildar.
But the writ petition challenge earlier was with regard to your
Report.
own land.
No. The writ petition before Justice Tapabrata was with regard to a report. Not see first page of the order. First page.
By
my clients, Ghulam Mohammed. I have challenged the report. Order was not passed. The writ court decided, take a decision. Decision was taken at page 51.
What was the challenge? A notice.
A report of the...
What report?
Report says that I have encroached the land of the private respondent, 9.88 square meter. I said, you take a decision on that. Even take a decision as regards my contention. My contention was there is a reduction of land. The authority have to take a decision in other way. Let it be against me. He has to take the decision. So this court directed the Tahsildar.
When the land was recorded in your name?
It's a long one. It's an old one.
Prior to the respondent or?
Prior to respondent.
Prior to
Yes.
respondent. Yes. What is your contention?
My contention is this entire village was resurveyed subsequently. And resurveyed, it was found that land, my land, their land and others' land went to the road which was constructed by the authorities. That is the reduction. That is the finding of the
So
authority.
that land may be reductions from your land.
No,
That is not
everybody's
finding,
land,
that is not,
everybody's land was
No, no.
reduced.
that is not a specific finding of the
No, that is
Tahsildar.
by the settlement officer, there is a finding.
Where is the finding that his land?
Tahsildar have not taken a decision.
Where is the finding that his land was reduced by construction or something else?
Yes,
By something else? Where is that observation?
I annexed the order passed by the settlement authority.
No, please. show
Tahsildar have
me
to take a decision, my lord. Tahsildar have to
Where
take a
is
decision.
that?
Page 39 of my opposition.
I am not asking about your opposition. I am asking about the observations made by the authority or the appellate authority, first appellate authority or second appellate authority, where it is finding that his land was constructed by the government.
No decision, no
Road
adjudication.
constructed by the government.
As I submitted, the entire village. was surveyed.
That observation must be in the order of the
The
authority.
entire village was surveyed by the settlement wing of the administration revenue department. And it came to the conclusion that this land is right to the extension of road.
Where is that? Where that observation?
No, it's not there, my lord.
You are saying your,
Annexed the
but that
document.
should be decided.
I annexed the document.
Single bench judgment, coordinate bench judgment clearly said you have to decide both issues.
But he himself
Number-
objected, the demarcation, he himself objected.
Demarcation as regards my occupying his land.
Definitely he
Yes.
will object. Why he will not object? His land is reduced.
Kindly come to page 44 of the writ petition. When Tahsildar issued notice for demarcation his property, he raised the objection. You should not demarcate my property. Kindly
That's-
come to page 44.
What I am saying, you are not understanding. His land was recorded. Some land is there, was there. That land should be considered by the Tahsildar at the time of measurement. If it is found reduced, why it is reduced?
My lord, the answer is in page number 55.
55,
55.
yes, 55.
In the middle, during resurvey work for being occupied by Nala
Where
under
signed have gone through the pleading of both sides, so paragraph so and so, survey so and so. It further revealed that initially the subject land bearing so and so 7 meter, which is later reduced to meter. During resurvey work being occupied by
Nala and
Nala
footpath.
assist. The resurvey was completed in the year 2013.
617.
That report was called for by this court, my lordship, in course of last hearing. They have not produced the same. Because Tahsildar has said nothing on this.
When you have obtained the plan,
Plan I'll show you. It's part of the petition, page 33, my lord. Page 32.
the plan obtained
7th of June 2010.
7th of June.
2010. By the panchayat, because the land falls within, at that point of time, it was within panchayat. So the Pradhan has issued the sanction letter along the plan sanction.
Please, sir, you please tell me when surveyor was, resurveyor was made in the year 2013. 2010, how you have issued the sanction plan on reduced land?
We have not issued, my lord. This is panchayat.
Panchayat, how?
We are appearing for the revenue department.
Panchayat is a party here.
Panchayat has not been, because the order has been passed by the revenue department, so the revenue has been made, my lordship. Not my point, my lordship. The matter needs to be revisited by the Tahsildar again, strictly in terms of the order passed by this court. Strictly. Let Tahsildar take a decision against me for taking any against his report needs to be filed. I have to be given a copy. A fresh decision needs to be taken. All the order has to be go.
What report do you want to file?
By order dated.
Report of revenue field staff in terms of order dated 11/12/2025. 11/12. What is revenue field staff?
They are the subordinate revenue officer in hierarchy. In hierarchy, they are lower revenue subordinates.
What their function?
They stay in the field. They assist the surveyor and the Tahsildar while holding the demarcation.
Demarcation was made.
Yes, they will assist.
Each and every land.
My lord.
So what report?
They would, based on the field measurement, they would prepare a report. And the report would be forwarded to the Tahsildar. Tahsildar give a notice to all the party stakeholders. Hearing would be done. If any person have any objection as regard report,
Objection
would be considered, then an appropriate order would be passed. Here in the present case, when a report was issued against me, I filed it before Justice Tapabrata Sab. Not to see first paragraph, the report was challenged.
So now what report wants to know?
No, because the report upon which the second revenue appellate authority said that my land has been gone to Nala, the report have to show.
That report
Yes.
required to be.
This was, yes, because,
proper adjudication.
yes, Tahsildar was not taken any decision on the line.
Fine. Monday. Their plan, they were extending the plan in 2017, the approval authority issued a stay order. You are violating the plan approved by the Petitioner. 2017. First of all, that should be decided as per the direction of the coordinate bench. On what basis that observation made by his land has been, same person participated in the settlement proceeding, he was satisfied with his reduced land, he was in occupation of that land, he did not raise any objection.
Tahsildar must say, Tahsildar must say that.
Comes.
Tahsildar must say that.
And for the appellant, plaintiff, second appeal upon admission being done by the division bench, it's for disposal, paper would be filed, it's ready, Lord. For the respondent, for the respondent.
What is the matter about?
What has happened? The only substantial question of law framed by the division bench is that based on two inconsistent plea, can a plaintiff claim a decree? The trial court said in the plain, two stands have been taken by the plaintiff. In that view of the matter, no decree can be granted. Supreme Court is very clear on the point. While admitting.
What are those 2 points?
At the one hand, because the suit is all about cancellation of the sale agreement. In one hand, I have admitted the execution of agreement. On the other hand, on the legal premises, I have said it cannot be enforceable. It's a void ab initio. So these are two facts which are pleaded in the claim, based on which I sought for annulment of agreement for sale. The trial court said on this ground only,
plaintiff has taken two pleas, it's not permissible, suit dismissal. It's an order has been affirmed by the first appellate court. So the second appeal came to fight. One question has been framed. I'll just show the division bench order not. Paper book may kindly be taken up, Lordship. Page 75 in the order of admission. There are two questions being framed. No reasoning has been assigned also.
Page number?
Page 75 of the paper book.
Yes.
This appeal shall be heard on the following substantial question of law. Whether the first appellate court erred in law in passing the impugned judgment holding that the plaintiff is not entitled to a decree as paid for in view of inconsistent plea raised in the plaint. B. Whether the first appellate court erred in law in failing to give reasons. So this appeal has to be heard out on these two substantial questions of law so framed by the division bench.
Both are ready.
But not, there is one difficulty. I am ready, but Lordship, today I am exhausted. Let it come, let it be upgraded. I'll do the matter tomorrow itself. I am ready with the matter.
Okay, not today.
Just. But even the appeal has been admitted by the Honorable Division Bench by Justice Rashekar Mantha and Justice Parthasarthi same. My Lord would see paper book. There are altogether, my Lord, 5 questions.
Who is respondent? Nobody is there.
Nobody is there, Lordship.
Not today.
Just not today.
My.
Item 24 to 7.
24, 25, 26, 27.
Similar matter. There are other similar matter which is placed before the court number 1. It is partially done so and it is fixed on Thursday. And then that matter will be released from this. There are total 8 matters. 4 matters at the bypass there and 4 to the this court and 4 are before court number 1. So already the matter was done today partly and matter was fixed on Thursday. So I am saying that this matter will be released and
Please give me the number.
I shall provide. I think 24 to 27.
Give the numbers all.
I shall provide.
Release. Release before. Matter is session. We have the Justice Bhatta. नाम दे दे नंबर दे दे why
Things we come to late 30 months. We appear in the lower court also. Like all the matters for the civil matter taken after 3 months. Go there.
you may go whatever you like, wherever you want to go, you can quote.
We are making submission.
Can refrain anyone to.
No. Bonafidely, we are making this submission so that this court may not.
If you have problem, you pray for adjournment. Where is the problem? Can you ask for rising the court before time or before exhaust of the list?
Normally, we used to.
Normally, I will follow my own. If you want adjournment, I will see. But you cannot say you rise.
No, we request the court. We cannot.
How you can request the court to rise?
Normally, the Kutchi call, we used to say that this is the difficulty we face.
Once you are say, many advocates say matter are pending. Everywhere this is saying that lots of matter are pending before the court. If you have problem, you can pray for adjournment. I will see. But you cannot ask or request any court to rise.
Request from the bench we can make.
How I can? How? Please show me the provisions. Where is the provisions? If you have problem, I will consider, but you cannot say you rise. Yes, item number 28. Yes, anybody?
Any appeals for one of the respondents? Let it not.
Not today. Not today. Next.
Right.
29.
I say not to.
Not today.
Onwards.
Appears for the petition, think of that's not today.
Not today.
Or I'm gonna respond. You are. Hearing for the petitioner, praying for not.
Okay, not today. No, this matter on Monday, 23rd.
Monday.
This matter on Monday.
Candidate for respondent authority. But I'm praying for not here.
This
You have 19, can it go 20? 20.
20. Okay, 20. Sixth or 19th? 19th, huh?
19. 34. I don't.
You have the private respondent.
And appearing the officer response.
Yes,
Company.
not today.
Right.
Right.
My senior appears for petition. Let it not.
Not today. Not today.
For respondent. Due to some concern, it is not available, so I'm praying for not available.
19.
Problem.
Yes, my revision petition, my lord, I am ready. After the concurrent finding, I have come with this honorable court. Against the order of the.
If I'm saying for not this, the council is not present for the state.
What is the matter about?
I was convicted by the trial court. I went for an appeal before the honorable session court. It was affirmed.
Under section?
It's under Forest Act.
Forest Act.
Forest Act.
Okay, not today.
39 also, my lord. Same council.
39 also I am for the petitioner.
Same.
Not.
39 I pray for Friday, my lord. This may be kept tomorrow.
Friday.
My lord.
39 Friday.
My lord.
Yes.
The 39 is relating to
It's
matter?
accident case 279 304A, my lord.
Conviction.
My lord, conviction.
देखिए এটা কি আছে Reply has not been filed. Ready? Reply is ready.
Yes. Keep by.
Okay. Day after tomorrow.
Day after tomorrow. Wow. Very fine.
I have a response.
Not today. Not today. Opposition. Reading is completed. Not today.
This kind of 42, 43, 44, I will take a matters. Commissioners find it cautious and for the official response.
What is the matter about?
The plaintiff has enforced some land.
Plenty.
Yes. Is there a case that they have not encroached the land and they were illegally evicted from the subject land? But
Evicted by whom?
by the department, revenue department. Revenue department is that they have encroached some private land. So the court is appointed the entity commissioner to file to do the inspection and file a report regarding whether the plaintiff is under this legal occupation or not.
Only possession.
Only possession regarding the occupation of the plaintiff in some others recorded land.
Have you solved the copy?
It's a report for. I'm submitting for the honorable.
ফুলে দিন তো এটা ফুলে দিন His contention is that he has already disposed of them. Then what? Here is all in already in occupation. They have been evicted. As per no, only order has been passed.
Yes. And the and passed the eviction order, they have filed this writ application.
The court will be sustained if the court will take exception to such.
Eviction order passed with the best is at page 14 of my report.
That was not challenged. That order was.
That is the eviction order under the RIT local regulation.
They have not challenged.
Not challenged. Despite of challenging that order, filed this writ application, which is not at all maintained.
All the three. All the three.
Yes.
All the three similar matter.
What did it say? This order was passed and order setting aside the order of demolition passed by the respondent. Subsequently, placed the passed and order in derogation to the order passed by the coordinating bench. Subsequently, we again filed a writ petition approaching this honorable court. Therein stay has been granted not to implement the order of eviction. And meanwhile, a coordinate bench passed an order appointing a special officer to ascertain the exact factum of land which the writ petitioner is occupation. Our case is that, Your Honor, we are in our recorded land. And department says we are encroached a government park. Let the report may be supplied to the parties, Your Honor, so that we can take exception to that, and the matter can be taken up for hearing.
So how writ court can decide? No, how writ court can decide?
Writ court has decided. Writ court has decided self-same matter. Then only the matter is
No, if the reports if submitted by the report says that you are the encroacher, then whether this can be decided by the writ court, you go before the appellate court. Appellate court will decide this issue. Yes.
But coordinate bench decided the same matter, my lord, delegated the fact matter on the principle of.
How coordinate bench can decide the disputed question of fact? report has been called for, oh, it's okay.
Yes.
But after coming report, how the disputed question of fact can be decided by the writ court?
The report has not yet been supplied, let the report be supplied to us, followed.
Demarcation is final, it's start to write the report.
Yes, yes,
that
ma'am.
are taken by certified copy from the single form. I have submitted before this order form with the original document. for it.
You are Sajjad Hussain. And who is Sabab Hussain?
The court attendants, who are file this writ petition before my lord.
Oh, three writ petitioners.
Petition, in what writ?
Demarcation.
Nazneen Begum.
Sajjad, Nazneen Begum. I have appointed of the center.
I'll take exception to the report.
Case number 4, you have submitted report, no? Case number 4.
119.
No, in your report. Do you have report?
Draft copy. One copy I have submitted, original.
When a special officer has submitted report, do you have copy of that report?
That needs to be circulated.
Draft copy. It cannot be circulated.
Mention is it is circulated, it's not so confidential, it can't be done, it has to circulate.
What is the confidential? Why it cannot be sub?
Because the supplier fee is only one copy,
Hmm.
original signature and fee. So already I need to take the Xerox copy and then I have to. Send.
The Xerox copy you supply.
That's suffice.
I will.
That will suffice.
Copies. I will take all the Xerox.
You must have taken Xerox copy. No, even if what exceptions you will find.
The thing is, this Lordship Honorable Justice Hirulma Bhattacharya, identical orders were passed earlier also. It was set aside. The matter was remanded back to the authority.
authority takes the same decision. So this court in the present writ petition directed the special officer, you hold an inspection in presence of the revenue officials. It was done so, report has been submitted. I have to see the color law. Because if it is, there are Supreme Court judgment which says any report adverse to the interest of the party have a right to take an exception. Writ court is saying.
No, I'm also with you.
Yes, sir.
Because any report must be go through the other side or the petitioner. You make a copy and give him.
So this matter will, it's tomorrow, Lord. Let me see.
Tomorrow, yes.
It's 42, 42.
All the three matters will be.
Tomorrow.
আজকে দিয়ে দিন বলুন tomorrow file. You file tomorrow and copy to be served today. Next.
And for respondent, we can say.
Friday. Okay, Friday.
This matter can be disposed of.
Why?
My lord, here the intention of the writ petitioner was as such that in the year 2012, wage agreement was not increased between the department authorities and the CMA. Subsequently, in the year 2024, a draft wage agreement was entered between the parties, but this thing was not perfect. I had approached before this honorable court. Honorable Justice Somensen had passed a specific order directing the respondent authorities to disclose their stand, whether they will be publishing their draft agreement or not. Department had accepted the same and they have stated that there are no objection regarding the draft wage agreement. We are ready to comply with, but ministry has to give concurrence. So this honorable court had directed the writ petitioner to
Approach.
to add ministry in the instant writ petition to get their stand. Subsequently, the ministry has been served and ministry has also given the reply in my mail ID and to the respondent authorities that the chief secretary has to decide, ministry has
Nothing to say.
as per the Andaman Nicobar administration, it can be granted. And they are, in their affidavit in opposition, they have admitted that there are no objection for wage agreement. So I pray that wage agreement in a
Can be.
conform manner, it can be done by the respondent authority. May this hear. Order dated meeting November 2025, this honorable court had directed to.
Which page number?
Order number, my lord. 19
Order.
November 2020.
No, this is Somensen order. Where is this?
First order.
Where is that? Oh. Oh.
March 21, 2025. Number 5.
देखो. So you have no objection. You have no objection.
We have not seen that we have no objection. This is a financial matter. So,
It should be decided by the ministry.
my lord,
The ministry has said, you have to decide.
my lord.
To read the name of the ministry. To the chief secretary.
Who has given this letter to you from the ministry?
My lord, from ministry. And even they will send me the letter also. It has been given to the director of civil service and state.
No, this letter is informed to the chief secretary Andaman to defend this case. Interest of the Union of India.
My lord,
Where is their stand?
my lord.
Affidavit filed by the Andaman Nicobar.
Where is that? Where is that?
Affidavit on behalf of the respondent of 1st July 2025. By way of affidavit, they have issued.
এই অ্যাফিডেভিটটা কোথায় আছে দেখুন তো।
Affidavit on behalf of the respondent, my lord, it has been signed by Hilary Kuti, Assistant Director Administration.
Affidavit of respondent. It is not an opposition. Affidavit, yes, page number 2.
Paragraph number 3. That the wage negotiation committee was constituted by order number 1657 dated 11 July 2024 to negotiate the charter of demand submitted by the Andaman Nicobar Cement Union for wage revision and other service conditions. The wage negotiation committee meeting was held on 24 August 2024 for settlement of revision of wages in respect of two members working on both the Andaman Nicobar administration vessel for inter-island sector with a respective majority union, that is Andaman Nicobar Cement Union. On the conclusion of the meeting, the majority Indian ANSU has mutually agreed and settled by a way of signing the draft memorandum of understanding with the Andaman Nicobar administration for implementation of the wage agreement. The approval of the competent authority is highly required, for which the same was sent to administration for obtaining the approval and the next and financial sanctions. The Eastern case was referred to personal law and financial wing of administration for obtaining concurrence, and all the three wings of the Andaman Nicobar administration has conveyed no objection. However, in pursuance to the OM dated 30.
No, the instant case is referred to personal law and so and so and so and so. Three wings so and so has conveyed no objection. However, in pursuance. What no objection? No objection for communication and approval of the finance. So.
Government cannot give no objection.
The approval of competent authority is highly required, for which same was sent to the administration for obtaining approval and financial sanction.
Personal law and financial. But however, in persons of peace.
And this communication has been communicated to you from
The ministry.
Ministry has said to defend the interest of Union of India and to delete the name.
So now what is your stand? After return of this letter to you, what is your stand now? Take instruction.
My lord.
Do you have copy? Have you solved the copy?
Yes.
Sir.
Monday?
Monday, my lord.
Friday, my lord.
Monday.
At least this, having heard the submission of the
Tuesday.
both side. No, I thought-
I'm there, brother.
Not today.
Just not today.
Not
Just not. I'm there for it. They have to file opposition law.
We have filed, we have served. Sir, we have served.
Affidavit completed. Affidavit completed.
Yes, we have.
You have not filed reply.
So just they have given me copy on 28th January, I just my reply.
Already direction was given
It's
in the month of January.
just 1 week's time, next week it can be taken up. This matter can be disposed. 1 week time for it.
Reply we filed, extension for filing reply is a prayer for extension for filing reply.
Yeah, appear for respondent.
Not time, you have to, for 3 days time, you have to filing reply.
Reply.
Okay, while Monday I will file your reply. In the meantime, I will serve the public. My senior attends for the private response.
I appear for official response.
But last chance করে রাখবেন। আগে last chance. Reply we filed.
This case I update for the restaurant. I'm playing 1/5 time to for evidence position and the extension of time. 1 minute.
Three occasion you have given chance,
1 week as last time to give.
25,000 pay.
But here last.
Extension of extension to file opposition is allowed subject to payment of 10,000 cost to the
As
petition.
a large as a large as thing.
This is the fourth time.
As a large and very last.
Within 3 days. Within 3 days. Affidavit in reply if any we file.
Fifty-one can be disposed of in the line of this judgment passed by Leadership Justice Shura Ghosh upon the division bench. Same. There. Also. Madam can come back.
You shop the copy tomorrow.
Accept. Ask me again. Shura Ghosh madam. Yes, sir. Tomorrow it can be taken.
Tomorrow.
Can be updated, can be disposed.
Okay.
Can.
You go through the judgment?
More.
I appear for respondent, madam.
Mr. Vijay Kumar is unwell. He has undergone surgery.
Okay.
So his appearance in this circuit is removed. So that is
As
taken.
requested, a reply has not been filed.
I'm handicapped because I'm a proxy. He has undergone a surgery in the leg. Mr. Vijay Kumar, that's the whole difficulty. He may not be in a position to appear.
अच्छा, लिखो ना. Please this matter. Yes.
I'm for the petition.
Reply is not been filed.
The council, there are two matters stacked, 53 and 54.
54, I appear on behalf of Mr. number 1 and 2.
What is the matter?
हमने जमा किया लगता है.
Demolition order. I have challenged the order on certain grounds. Some protection has been granted by this. So both the matters have to be taken up.
There is no appellate authority. There is no appellate authority.
There is an appellate.
Violation of principle of natural justice. The order is passed
Oh,
without
yeah.
hearing me. Then Lordship will read court, Whirlpool's judgment 1998, SCC1.
So no opportunity was given.
Nothing.
for-
Adverse material collected, no report given, adverse decision was taken. Supreme Court have said that decision has to go.
This one and another
54.
54.
When Kumar is there, 54, because who has undergone surgery.
Monday?
Monday.
Monday.
The interim order may extend it, 53. There's an interim order subsisting that needs to extend it, 53.
There is no interim order extended. Which item number?
53.
53.
is an interim order.
दोनों में आप DC के लिए ना.
There is no interim order.
55.
No interim order extended.
Yes, order dated
So 20th forward.
2011-2025 by Justice
BMC.
Kalsun Jamil.
There is no interim order.
No, they are seeking for implementation of that order, 54. I challenged the order in 53.
54 पे হবে হ্যাঁ ওটা অর্ডারটা স্পেসিফিক নাম্বার ঠিক আছে তো প্রথমটা হবে
Problem.
55
I appear for respondent.
They have filed the dividend replies. That's the problem.
today filed.
Today,
Then they are filed.
Yes, where is the reply?
They have filed the proposal.
আচ্ছা দেখুন বুঝলেন reply has been filed. Affidavit.
ये needs open for variable.
எனக்கு தெரியாது நானே இப்போ
Affidavit exchanged. Affidavit exchanged. Reply. Opposition filed.
Respondent number 6 has filed their.
I see.
And respondent number 3, 4, 5, 6 further accommodation to file opposition. Where is that?
I'm for 3, 4, 5, 6.
Why you have not filed?
Ready here.
In this way, we cannot adjourn this matter.
Certain document.
Several, one,
No, only this is second acknowledgement.
this is third time adjournment.
Certain documents are there.
No. You have to file.
I will file there. Well, it may be on Monday, can by that time I will let it on that.
Let me the copy, so I'll file my reply on Friday, so let it be on Monday.
Yes, I will start. It is ready here. But the document is there. Yeah.
Affidavit in opposition will file.
Petitioner says, matter of keeping electricity connection. What happened?
You are appearing for the respondent.
I am for the petitioner.
And who is respondent?
Usually your petitioner is the advocate, the panel advocate of the electricity department is there. I served the copy upon the department concern on 4th of February. Thing is that my application was submitted on online, it was accepted. The difficulty is that, Your Lordship, after acceptance of my application by the Assistant Engineer Electricity, what the Assistant Engineer Electricity did, he sent a letter to the Tehsildar concerned, stating that to intimate the concerned department whether the petitioner is in settled position or not. I've annexed that letter also, Your Lordship, and almost, Your Lordship, the year is going to lapse, Your Lordship, the applicant is pending.
Whether rejected or not.
No, nothing has been done, nothing has been done.
So let him done first.
Yes, the thing is that, Your Lordship, it may, you have to. Nothing has been done. Your Lordship may kindly come to page number 17, Your Lordship. Last annexure, page 17. The electricity department, what we did, Your Lordship. Though he has recorded in this letter that within 30 days, as per the act, the electricity has to be provided to the concerned party. But for ascertaining whether the petitioner is.
Have you served the copy to the
Yes,
other?
on 4th of February, I have served, Your Lordship. To both the department, Assistant Engineer Electricity as well as Tehsildar.
Have you served the copy? Last occasion it was directed to
Yes.
serve the copy of his petition. Where is the affidavit of service?
I will file it by tomorrow.
Huh?
By
Tomorrow.
Yes, they file on 4th of February.
Tomorrow it will upgrade for them. Uh, 58 is same.
57, same.
Same. 57, 58. No.